Hey everybody, welcome back to the channel. As promised, we have more hits rolling for you today. Post Bruin, we are #filed on another lawsuit. This one, B&L Productions versus the 32nd Agricultural District. If you haven't been following along on this one, it has been a long and hard battle. I personally have fought in for several years, and it's finally culminated to this. This basically is a CRPA response, along with Crossroads of the West response to legislation that happened from Senator Dave Min in 2020 banning gun shows at the Orange County Fairgrounds. That might sound a little bit familiar to you if you've been following along with legislation this year, as we've seen, I think, it's either 2 or 3 bills that have just been signed by Gavin Newsom that would ban gun shows not just at the Ventura Fairgrounds, but also another bill that bans gun shows at all fairgrounds in California. This lawsuit hopefully will help when we battle those laws as well. But really what you're going to see here is actually a very similar lawsuit to one that we've already won. And you kind of got to ask yourself on these, how many lawsuits actually need to be filed before Sacramento gets it? If you want to take this back a little bit, actually going to San Diego, where they held a moratorium on gun shows at the Mar Fairgrounds. CRPA filed a lawsuit against that one in 2019, not just on Second Amendment grounds, on First Amendment grounds, and on 14th Amendment grounds. The opinion from the judge was pretty decisive. Basically, I mean, there was a whole bunch of talk in the opinion about scrutiny. What you find here is this. This was an argument between content-based or content-neutral law. The opinion reads, a law that is content-based on its face is subject to strict scrutiny, regardless of government's benign motive, content-neutral justification, or lack of animus towards ideas contained in the regulated speech. Defendants' proffered content-neutral justification does not render the moratorium a facially content-based policy content-neutral. Indeed, because the speech at gun shows is likely to be predominantly, if not exclusively, favorable to gun shows and gun rights in its practical operation, the moratorium goes even beyond mere content discrimination to actual viewpoint discrimination. So, proof's in the pudding here. Shutting down gun shows does more than just discriminate on content. It discriminates on viewpoint. That is a First Amendment claim, folks. And I don't really know how else to put it. You can't take these gun shows away simply because you don't like guns. And really what that moratorium was all about was public safety. That was their reasoning. They said that gun shows pose a threat to the safety of their community. And we get this decision from a judge who seemed to have an understanding of the Constitution. They went to further write, a regulation engages in viewpoint discrimination when it regulates speech based on specific motivating ideology or perspective of the speaker. The government may not regulate use based on hostility or favoritism toward the underlying message expressed. Indeed, the complete ban on gun shows effective by a moratorium would not even survive lesser scrutiny because it unquestionably burdens substantially more speech than necessary to accomplish the district's alleged goal of ensuring public safety. Right there. Where is the intrinsic value? The intrinsic value is obviously in being able to freely speak your mind. That is much more important than a very ambiguous goal of creating public safety. So let's go back to Senator Min and Senate Bill 264. If you think he's going to say the same thing, you are probably right. Let's look at Section 1, Subset E, gun shows bring grave danger to the community. Same argument that's already been overthrown. This is why we're filing the lawsuit. This lawsuit is B&L Productions v. 32nd Agricultural District. It is directly against this Senate Bill 264 that got signed into law in 2020. Stay tuned with it as it goes along. I'm assuming it's going to go along pretty quickly since there's already legal precedent showing that you can't do this. But the file is the same. We are challenging on Second Amendment grounds, we're challenging on First Amendment grounds, and we're challenging on 14th Amendment grounds. So if you like seeing this from CRPA, go ahead and give us a like, a thumbs up, and go ahead and share these videos. We're trying to get this out to as many people as possible. Look to the website as well if you want to follow along with the progression of these lawsuits. We're going to be updating as much as we can with plenty more lawsuits to come. We'll see you next time.